Changing numbers and styles over 6 decades. My intention is to move from context, largely in numbers, to comments and issues, and then to your questions. A few warnings. There is some inconsistencies in the data. I've used a variety of sources. Some of this is impressionistic. Covering 55 years in 30 minutes is something of a challenge, but for most of the period I was there or thereabouts, and here you can see where I was. At these level, picking up some national work, which was very interesting, gave me insights into what other people were doing. Some time away from higher education, and then back to South Bank to do some part-time teaching, some supervisions, and a bit of writing and conferences and things. So, to some numbers. These are very familiar. Crucially, about 3.4% of the age cohort went into HE in 1950, and about 33% of a larger cohort went into higher education in 2000. The England and Wales population grew over that period. There you are. And we can try to compare that with opportunities in the profession. The degrees are UK level data. The stuff on the professions is, I'm afraid, England and Wales data. But it's still interesting. There are the degrees in gross numbers. That's the number of barristers, not just people going into the bar, the total numbers in the profession. And there are the total number of practising solicitors. And of course the first degrees are not just law degrees, they are all degrees. But the orange tower, of course, rises more steeply than the other two towers. And now there is talk that too many people go into university. Look at this another way. England and Wales barristers and practising solicitors as a percentage of the number of UK first degree graduates. There it is. The barristers, and there's the solicitors, and we've got a definite downward trend. So competition for places in the profession is getting stiffer, and the opportunities are thinner. A few key dates: 8.5% of the age group in 1962 going into higher education. Robbins' report suggests a trebling over 20 years, setting up the Council for National Academic Awards to bring the polys into scaled up higher education. The CNAA operated quinquennially at institutional level and quinquennially at course level. The first 30 polytechnics were formally announced in 1967. The Ormrod report in 1971, I'll say a little bit more about that in a moment. LEA removed from non-university HE in 1988. 1992, the Further and Higher Education Act gives us new universities with degree awarding powers. The CNAA then is dissolved, HEQC is set up, which is predominantly institutional level accountability. And then the Quality Assurance Agency replaced the HEQC. Looking at Ormrod, a few of their proposals. The notion of academic and vocational being part of an integrated whole, probably not yet achieved. Diversity, considerable progress, but in the upper reaches of the profession, still some way to go. The three-stage model was articulated in Ormrod. The yellow bit of this one is fairly traditional stuff: basic knowledge of the law, ability to apply it, which is abstract concepts, I do real facts. And then, more interestingly, understanding of the relationship of law to the social and economic environment in which it operates. More of that in recent years. In the early years, that was not really, I think, pursued very much. The academic stage should be spent at university or college. A law degree is the normal mode of entry to the profession. How desirable is that? Isn't the profession enriched by having graduates of other disciplines amongst its numbers? Quick expansion, and now apparently we've achieved that. Alternative routes, and then the idea that cost should not be a barrier. That too, I wonder whether we have achieved it yet. But you see an increasing academic autonomy, and I think we also see increasing use of that autonomy as the period goes on. The pre-1992 universities, of course, always had degree awarding powers, but the professional recognition of their law degrees was a matter for the professional bodies. They used templates which were applied in a rather clerical manner. There was no depth in the discussion about the curriculum. And that led us to a largely standard menu of doctrine exposition and testing of its application through vignette-style advised-Bert examination questions. And that model was epitomised, I think, in the London External LLB, which the soon-to-be Polytechnics used in the 1960s. Now, after Robbins signalled higher education expansion, CNEA provided the opportunity for other models in the Polytechnics. One or two polytechnics, Lanchester and City, opted for business law, first off, inserting some business modules and narrowing the range of law modules. But many others, including Kingston, followed the London external model with some innovation in the options offered. I think that we therefore had, in the early years of CNEA, largely more of the same, mainly to be sure of the professional exemptions rather than to satisfy the CNEA, and perhaps to reflect staff expectations. One teaches as one was taught, perhaps. This first paragraph could be written now, I think, but it was written in 1972. The problem with legal education, say Thomas and Munger, as with other mature disciplines, is how to reconcile the liberal tradition with the demands of the world of human affairs. Much of its theory and practice proceeds on the basis of certain dominant assumptions, hidden or only half articulated, concerning the nature of law and the role of the lawyer in society. But then they turn to the idea of the core course, which is central to professional exemption, the notion of the qualifying law degree, which there has been considerable change. The advent of SQE does give university teachers some more freedom about the curriculum. And that is probably just as well, since a diminishing proportion of law graduates will actually go into the profession. The others will need some robust and clearly demonstrable transferable skills, that understanding of human affairs. They need to look at things like argument, justification, decision-making, negotiation, motivation, that sort of thing. So there are tensions between knowledge and understanding, between the static and ahistorical, and the dynamic and changing, between the descriptive and the analytical or critical, between the discrete closed and the permeable open view of the systems, between doctrinaire approaches and consequentialist approaches, between training and degree-worthy education, between drills and skills. QAA has something to say about values in higher education in first degrees. Within the discipline, they point to understanding key aspects systematically, but they do point also to knowledge which is at the forefront of defined aspects of a discipline. And then they do talk about conceptual understanding, devising and sustaining arguments, solving problems, and ideas and techniques that are at the forefront of a discipline. More broadly, they talk about an appreciation of the uncertainty, ambiguity, and the limits of knowledge. And students should be making use of scholarly reviews and primary sources. The transferable skills necessary for employment include decision-making in complex and unpredictable contexts, and the ability to be trained further. And in 2019, I take this from one of their pieces, this is not honours worthy. Inadequate understanding of the subject-specific theories obviously is not honours worthy. Insufficient evidence of background investigation, analysis, research, inquiry, that is not honours worthy. Over-reliance on set sources, inability to critically evaluate arguments or consider alternative views, limited ability to solve problems or make decisions, little or no creativity. So there are obstacles, there are frustrations. My impression is that an increasing proportion of entrants have previously been taught to the test. They arrive expecting, as a matter of prediction, and normatively as a matter of entitlement, be told the right answers. Assumptions which are difficult to dislodge. I wonder sometimes if they've been reading Ronnie Dworkin's No Right Answer, where he said, for practical purposes, there will always be a right answer in the seamless web of our law. My problem is knowing when we have found it. But the law does change. Innovation happens. Law graduates must be equipped to get over that. Look at this comment of John Picton's on a recent Supreme Court case. He says, after careful analysis of the judgments, he says it is not yet possible to tell how the future law will develop. And here from the Court of Appeal, even more recently, Sir David Richards saying, it is not easy to discern from the authorities the precise scope or limits of the doctrine of merger. So, who decides? And what influences that decision, given that it cannot be simply deduced from the authorities? And then we have the understandable, probably essential use of multiple choice questions, but that can work to entrench expectations of right answers. The SQE questions are quite sophisticated MCQs, but how far even should those affect the LLB style throughout the curricula? How many law graduates will find a place in the professions? Furthermore, there's an additional pressure. Lecturers are going to be concerned to avoid poor student outcomes, to avoid low student satisfaction, and consequently they will be under pressure to teach students right answers and mark them right when they are presented with them in the assessment. Nowadays, students are customers, many of whom think they have bought a product, a good degree, rather than simply the opportunity to develop, or in old-fashioned terms, membership of a special society through which one can progress by degrees. In 1977, with the Unfair Contract Terms Act arriving, I wrote a piece on students as consumers who had contracts rather than membership, and it was rejected by a journal which had a clientele of university administrators. The editor said that a contract had nothing to do with membership. But by contrast, now, of course, we have very substantial commercial pressures to inflate grades, and so on. A quick look at styles. This is a very rough sketch. Doctrinal exposition was there at the beginning of the period and is there still, and so it should be. So too its application, and so too its evolution, which we appeal to from time to time. particularly in trying to explain the advent of a landmark case and its antecedents. Jurisprudence was there at the beginning, partly as a badge of academic respectability, but I think this is very impressionistic that it has become more integrated in more recent years. Law in context, a very welcome development in the 1970s. Wiedenfeld and Nicholson launched the series of books with Attia's Accidents, Compensation in the Law, and that still has legs. And you had law as a social science. Law and a social science, law and sociology, law and psychology, and of course, which is quite another thing, law and economics. And you had sociology of law, where law became an object of sociological inquiry. And drawing on these threads, the development of politically aware work, critical legal studies. Then clinical legal education, which existed well before the 1970s in the United States, but in this country I think began in Warwick and at South Bank only in the 1970s. There has been an excellent and very welcome crescendo in more recent years. Then problem-based learning emerges, and then law tech as the new kid on the block. I'll say a bit more about those later. In reflecting over the last few years as what's going on in legal education, a break and then coming back to it is thought-provoking. I was taken back to my own time at LSE, and the motto of the school, rerum cognoscare causas, Virgil, Dryden translates it as happy the man who, studying nature's law through known effects, can trace the secret cause. It begins to capture something. I wasn't aware of it at the time. It was just there on the badge. I took no notice. But with hindsight, I think it says something. I count my time at LSE as good fortune rather than good judgment. I stumbled into my UCA choices and so on. But I found, I later appreciated, that LSE at that time was in the vanguard of going beyond the dominant model of doctrine plus internal consistency plus application. So the motto led to a kind of, captured as it were, a kind of functionalism, knowing the cause of things, how do things work, evaluating those consequences. And the people doing it, I again later appreciated, were of very considerable stature. Otto Kahn-Freund, a polymath, wrote The Labour and the Law and many other pieces. Bill Wedderburn, author of The Worker and the Law, introduced the first cases and materials book for labour and law in this country. Groundbreaking work in company law. Robert Stevens, John Griffiths, Politics of the Judiciary, but also a lot of work in setting up administrative law as a discrete and worthwhile subject in its own right. Stanley De Smith, who wrote the book on judicial review. Toby Milsom, probably the leading legal historian of his day. Simon Roberts, whose legal anthropology work is really interesting. His book, Order and Dispute, is well worth reading. The two of those two had to teach me land law, and they didn't succeed very well, but that was my fault, not theirs. Cyril Grunfeld wrote a book on trade union law and then went off to ACAS as their legal advisor, dealing with mediation, arbitration, conciliation, codes of practice, and so on, actually at the cutting edge of the interaction between the law and industrial relations. Bill Cornish, again, some considerable work in legal history. Aubrey Diamond, who was much connected with the Consumer Association and things like that, he wrote The Consumer in the Law, which was a Penguin book, came out at much the same time as Bill Wedderburn's Penguin, the Worker in the Law. Really interesting people, and they were teaching us as ordinary undergraduates. We were taught by them. At South Bank, a polytechnic, of course, in 1974, the brief was to start the law degree, so we did it. But regional planning meant that only 30 students could be admitted, and that looked uneconomic to me. It put an obligation on us to do something different, so we emphasised method. Law is something that is made in use and can change. And by 1980, this academic concern with law in action led us into clinic. And indeed, my own cherished Law and Society module gave way to clinic. Only Warwick was going into clinic at this time. We were motivated by the academic conviction that the phenomenon that is law cannot be fully understood simply by reading the products of its processes. Instead, one must understand those processes which involve evidence, procedure, financial factors, people, their circumstances, the context. Much more Mark Galanta, Why the Haves Come Out Ahead, than Ormrod. So by the 1980s, we had level 4 students being briefly exposed to local CAB legal advice sessions. We had a member of staff, qualified solicitor, experienced and insured, who supervised and acted as honorary legal advisor there. Then the second year of the course, every student took part in a long accident case simulation, and there was a course of lectures on accident prevention, public and private insurance, compensation through the state and through tort law, remedies, the role of lawyers, and so on. And the third year students, some could take an option in welfare law back to the CAB, supervised and assessed casework, supplemented by some other written work. The current position at LSBU is recognisably similar, although the patterns, the scope, the labels have changed. There's a general clinic, a family law clinic, and plans for a human rights clinic, but we have not yet achieved clinic for all. And law tech has arrived and is flourishing. Students making apps for local organisations, collaborating with computing students in so doing. It's certainly a great idea with a very considerable potential. Some questions about skills and legal education. What is a law degree about? What is it for? How do we square degree worthiness and work readiness? Is there a robust hierarchy of skills? Is third-rate philosophizing of a higher order than first-rate professional practice? People look at Bloom's taxonomy, which can be taken as a hierarchy ascending from the merely mundane to the intellectual heights. I wonder whether that is to oversimplify. Let's look. Knowing is at the ground of it, then comprehending, then applying, then analysing, then synthesising, and at the peak, evaluating. I have reservations about the layering and simple notion of finding a higher order. Look at it this way. Explaining things to others certainly helps with comprehension and with retention and application. If you know something, you've got to explain it, and that does something to your knowledge, and it starts things going in your brain. And those are the things which I think are important in analysis and synthesizing and evaluating. So the lines I've drawn across this pyramid are very permeable, or perhaps misleading. Look at it this way. A well-trained plumber can do more than install, repair and replace by knowing, comprehending and applying instructions. We expect her to diagnose faults. We expect her to design and install domestic central heating systems and to advise on whether a combination boiler is suitable, and soon it'll be heat pumps and all that sort of thing. She cannot possibly complete such tasks competently without, in addition to knowing, understanding and applying, analysing, synthesising and evaluating. So what to do? Emphasise active rather than passive learning. So let's look at the styles side again. Here's that slide, and you see I've drawn in the right an arrow showing a direction, and I think it broadly stands up that the further down that chart you go, the more active the learning activities are going to be. And that, I think, is healthy and to be encouraged still further. To conclude then, a word or two from Carl Llewellyn, from the Bramble Bush, where he talks here about what the law means to those whom it affects. And he says, not with paper theory, but with living fact. And if that be treason, make the most of it. There was a time when it certainly was treason. I think we've passed that at least. And then Eliot in The Rock, where is the wisdom we have lost in knowledge? Where is the knowledge we have lost in information? So perhaps a little further reading. I do commend absolutely to you Pat Layton's piece in the latest Law Teacher. It's short and very good. Vanity perhaps leads me to remind you of my wordfulness for Neophytes paper. The Bloom stuff comes from that paper I gave in Prague, and two earlier pieces. This one on clinical legal education focuses on skills, and this one looks more at the broader context and worries about overemphasis of disputes and downplaying of structures and contexts. Well, thank you for listening. I look forward to your reactions and questions.